she went to get her. Hello, she went to get her vitamins. It's better, right?
Yes, it is.
Not too crowded.
Not a problem.
You look tired too.
Jose.
And 10.
No, not you.
No, I tired.
And 10.
You don't look tired.
And 10.
My coworker said when you go in the class, I was that.
And I suffered my chest. That's what they do.
You got tea?
I feel it
Yeah,
on
I
my
have one too.
shoulders. Yeah, tension on my shoulders.
Then you trying to breathe hard now. I tell her she trying to breathe hard.
Because I came them stairs.
I have to go back up.
Dude, this one, she on the phone, she alright, she good for the long haul, okay?
Applying about trying to transfer restructure.
No,
Over
right
there.
there.
And it tax, stamp tax payable. So she said I need to bring up.
I just wait on her to make it started. Well, look up that man, let me see who he is.
Who's
Who you talking about? Oh, wait a minute.
Her desk is just papers.
I never heard of it in my life. Cause I heard Tiffany talking about this. She went to church last night.
Last night was awesome. John Gray. You didn't know John Gray?
Yeah.
This one did,
John
John.
Gray.
Yeah. There was someone tonight, 7 o'clock.
She was telling me like,
William Murphy tonight.
after coming.
John Gray was.
John Gray was awesome.
Within ministries or, cause that's what she was working on.
New Jersey.
So each ministry.
She going to Murphy tonight.
Laverne, goes there, so she told us.
It's funny that
Purchase, each purchase will have an estimate.
William Stephen Moore, John. So which one you were last night?
Stephen Monroe, the landscaper.
It says that she started at least that was the same.
This is the one that went to school with her?
yeah.
Think
Okay.
it used to be.
Okay, William Murphy
They
the
have,
third. John.
they literally started. They have to be finished by tomorrow. That's what she was telling me.
John
Yeah,
Gray's
they
not
have
speaking
everything
anymore
is
in the morning.
Has to be, that's what she said. She told me that.
Amy?
Listen to her.
Oh.
Everything by tomorrow. For this Monday.
William Murphy's a son.
Oh, that's what she said, she's a psalmist. You ever heard of that?
Sean Gray's any other night, always done. She
Yeah,
has
John
like,
Gray's done.
hi.
It was son.
I couldn't work for them. I know there must have been a crowd last night. It was packed day.
Even in a short second, 4 minutes went.
Really? No.
Yes.
That's a-
You went?
It's fast.
Yeah.
It's went very fast. Okay, let's start the introduction while we wait for her. So in this segment of taxation, we're gonna look at trusts. We're gonna look at offshore company administration. Next week, we're gonna look at private trust companies. And we're gonna look at succession planning. Then after that, when we do succession plan, we're gonna look at how inheritance works in the UK. And then the following week after that, we're gonna look at taxation of companies. And then we look at taxation of trusts. Okay? Look, she got a grocery store. What happened? You wonder why everybody getting you don't have?
Everybody up?
They all have snacks now. There's snacks here.
My lunch bag here?
She's here for 9.
Yeah, she come, well,
She come prepared.
I
So-
get tired, so we can't stay that long.
No, we you
We got you.
You got you.
Yeah.
Okay? So I normally start off with the fundamentals of trust. Because it doesn't make any sense talking about the taxation of a trust if you don't know what a trust is. So who knows what a trust is? Or don't know? It's easy to say you don't know.
Yeah, I know, tell me what it is.
Yes, you know. Yes, you know. You know?
With a trust?
Uh-huh. You know. You know.
I know the basic idea, but I've been out of it for a little while, so you remind
Okay.
me.
All right.
Praise the Lord.
Why are you saying that?
Because then you can believe hard, no, listen.
Okay, so what I started out by giving you is a history of trust, how it all came about. Going back to the very beginning, you know when you watch those movies where the soldiers go to war with all that big armor on? Okay, so in those times, when a soldier would go out, he would tell his neighbor or his friend to take care of my property and my children until I come back. And in those instances, when that happened, if he died, his friend took everything.
The children underway.
Took
The
it.
children, wife, and land, and everything.
Oh, okay.
At the same time, you had the kings saying that they needed to be paid their taxes. And so they had different tenures of land, the same way we have it today. And so what people try to do is to circumvent paying taxes by giving their property to someone else to hold for them, as they say, in trust for. And so when the king first heard of that, he said, guess what? There's no more of that. Because I'm not getting paid the taxes I'm supposed to get. So what they decided to do is to circumvent all of that. Then let's say I'm giving to you in trust for. And that's how the whole concept of the trust came about. That someone is holding something in trust for someone else. So in essence, a trust is a legal arrangement where I give my legal interest to her and the equitable interest to my beneficiaries, of whom I can be one. That's what a trust is. So in my first slides, I give you the whole history of what it is. So when we talk about trust in medieval time and going forward as they develop the concept is where we have what we call the maxims of equity, which means this is where the courts came up about being fair. Over time, we had the regular court and then we had courts of equity. They all merge into one. So whenever a decision is made, is always what's common law and what's equitable. That's trust 101, okay? And of course, with equity, there are equitable remedies. A common law remedy is damages. When you speak about equity, then we talk about injunction. Injunctions mean you stop what you're doing until we decide who really needs to move forward. Then you get to rescind the contract. Or the one that most people ask for, may have to do with land, is specific performance. I paid you my deposit, I now want my land executed. So those are equitable remedies. So I went through and gave you the history of the medieval time, which is about the use. When you say someone is going to use your property and then move into the trust, and the trust for. So that's just history, and you can read that. If you're interested, I can give you a whole handout with 35 pages that speaks about the history of the trust. If you're interested.
Don't say you're
I only need to know what it means.
Huh?
I only need the definition.
I can tell you, John, 100 pages easy.
I'm only letting you know. Now, when you talk about a trust, in the practical side of it, sometimes people cannot distinguish a trust from other concepts. So a trust is different from a contract. What's the difference? Go ahead.
There's no consideration in the trust.
No, there's no consideration. What else?
A contract is legally binding.
Mm-hmm.
A contract does not necessarily have to be written.
Mm-hmm.
You have an oral contract, right? But the trust, in most trusts, it has to be written
Mm-hmm.
to be legally binding.
Yes.
But a contract is normally two parties.
Mm-hmm.
A trust that can be more than two parties. that's it.
She got it, she got it. What's the difference between a trust and bailment? Mm-hmm. And when people hear that word bailment, they wonder what is that? You know bailment?
In the top right there, so you can move your car, there's some colors going somewhere.
We could let her teach till you come back.
Oh, huh?
Yeah. Just going through all the
She knows though?
contract.
You know the difference between trust and bailment?
No, ma'am.
2 seconds.
So we don't have class on Saturday, eh?
No, we don't.
So this is a place of Saturday.
Right.
It's on page 8.
Okay.
Front first page, yeah. She didn't really say it was different.
Classes ends on November 28th.
On a Tuesday, yeah. Yeah, like why this exam gonna be December before Christmas? 'Cause
No.
It's
End of January?
It's the end of January.
Yeah.
Cause the beginning of January is rough. No child, this room is made us more cozy, we were having discussion.
Cold?
Cozy.
Oh, that's nice. You're building a friendship.
Yeah,
Hmm.
relationships.
You already know each other, believe me.
Okay, so what's the difference between a trust and bailment?
Oh, we were supposed to be reading that thing.
Well, she didn't tell us the difference. She told us how they're similar.
I don't know.
Bailment?
I don't know.
I think Bailment it's is similar, but safekeeping.
Safekeeping?
I think it's temporary, it's temporary.
No.
No.
Like a safety deposit box.
No.
That's what
Actual
safe,
box.
yes. That's what bailment is. When you go to the bank,
Right.
enter the contract,
And,
and you
okay.
say, I wanna rent a box to put my
Keep my
necklace in or whatever it is. Then the bank has a duty to make sure that wherever it stores it, that it keeps it safe and in the same condition as brought in. And also that it doesn't give the property to someone else
Okay.
versus a trust. What's the trust compared to bailment? The settlor cannot go back and say he wants the assets,
Right.
because the legal title has already gone to the
To somebody
trustee.
else.
Yes.
Mm.
Got
So
it?
you're saying a trust cannot be broken?
It depends on the type of trust, not broken.
Well, I mean,
Yeah, it could be revoked or it could be irrevocable.
okay,
But in most instances, most trusts are discretionary,
okay. Okay.
okay? What's the difference between a trust and an agency?
It's an agent. There's normally an agent that is set up. Most trusts, there's not an agent.
Mm-hmm.
An agency is almost like a bank account where you can make deposits and withdrawals. It's not so, it's much easier to set up than a trust.
Okay, that's from that aspect. But when someone becomes an agent versus in a trust, when a person becomes an agent, what do they become? If I'm an agent of an entity, you become a representative, then you have a duty to whoever employs you. So as a trustee,
Right.
you have a duty to the beneficiaries.
Okay.
So there are different arrangements, but there are some similarities. The difference between a trust and a debt. You know what a debt is? You owe somebody money.
Somebody,
Right.
In a trust, do you owe anybody anything?
No.
No, you don't.
no,
So that's the difference. Once the assets are transferred to the trustee, legally, that's it.
that's it.
Versus if it's a
Okay.
debt, then you owe someone and the creditor can go behind you to get it.
Right, okay.
Now remember, when you establish a trust, there is a time period in which the trust can be attacked. In case the trust is a fraud or a sham, if you're trying to defraud creditors.
Okay.
But in most instances, it's not the same as a debt.
Okay.
Difference between a trust and a power.
So power of attorney?
No, when you deal with trust, the way the clauses in the trust instrument are written, it can either give you a power to do something, or it's just right out, it's a trust. So one is imperative and one is discretionary. And then a trust versus administration of estates. What's the difference? Or how are they similar? When I say administration of estates, you know what I mean? Succession planning.
Okay.
How is a trust similar to succession planning? You can read all of that tonight. Just think about it, make it practical. Because if you think about it practically when we discuss, when you read it is easier. If you read in the words while we discussing it, when you get home, you still will be lost, trying to figure out what exactly was it.
They're both the beneficiary because the trust is for the beneficiaries and the administration of estates.
It's for the beneficiary.
For the beneficiaries.
So both. When someone dies, whether they died with a will or without a will, which we will do next class, they become a fiduciary. The assets of the deceased are put in their care, trust, and they have a duty to carry out the wishes of the deceased. the same way as a trust. The only difference is with a trust, you're following the instructions that are written in the trust deed versus administration of estates, you're following the instructions that's written in the will, or you follow the Inheritance Act, where the law stipulates how the funds are to be distributed. That's the difference. Okay? But both positions, whether you are a trustee or you are a personal representative, you know what I mean by personal representative?
Speaking on behalf of.
No, personal representative means you're either an executor or you're an administrator. Administrator appointed by the court, executor appointed by the deceased. So whether you're a trustee or you are a personal representative, you are acting in a fiduciary capacity, which means you have a duty to your beneficiaries, and you can be sued. Okay? So I already gave you what the definition of a trust is. And it says a trust arises out of the conscious act or declaration of an individual or group of individuals. So a trust can be any type of assets. You could have paintings, buildings, land, jewelry, what is it? Horses, anything. In the Bahamas, our job is to structure your assets for your heirs. So there are three main parties to a trust agreement: the trustee, the beneficiaries, and the second. So a trust can be created under three conditions. One, he must have the intention of words. He must want to create a trust. His words have to say, I want to create a trust. The second one is he must know the subject matter. He must know his assets, where they are. And the third thing is he must know his objects. Who is he giving his money to? His beneficiaries. So if you look at it, it's the same as when a person's write a will. They must know all of their assets, and they must know who they're giving their monies to. Only difference is with a trust is that the legal title passes to the trustee. Versus in a will, it is ambulatory. It can change any time while you're living, not until you die, it takes effect. So people who walk around and say, my name is in the will and I own this, it's no effect.
Right.
Okay? So there are different types of trusts, and I listed a few here: charitable trusts, purpose trusts, fixed interest trusts, protective spendthrift trust, a discretionary trust, and a revocable trust. Most trusts will not have a name on it. You know the type of trust it is when you read the clauses. The provision that was in the trust, it will tell you this is the type of trust it is. So if it says that I'm giving my money to 4 different charities, you know it's a charitable trust. If it said that this trust is just set up for this activity, you know it's a purpose trust. If you see it says that the trustee must make, in his sole discretion, must distribute the income and capital to my beneficiaries, then you know it's a discretionary trust. If it says that you must give my beneficiaries $5,000 a quarter or $10,000, you know it's a fixed interest trust. So everything is based on the wording. How it's worded, then you know the type of trust it is. And of course, whether it's revocable or irrevocable, there's always a clause in it. If it is revocable, and it will say that this is revocable or this is irrevocable. So it's there.
You could add settler directive if
It can be a settler director trust. Again, you look at how much powers you've given to set law and to make sure that it's not a sham, that he doesn't have too much control. Even though in the Bahamas we've added in a section where the set law can give the trustee directions as to how to invest. And the trustee is not liable if he follows his instruction. But again, like they say, you can't give him too much control, because the trustee acts in section 4 and 5 actually state how investment should be done. So even though he's giving you directions, you have to make sure you're still within the parameters of the law. Okay? So a trust may be classified based on 3 items: either the purpose, controlling the release of funds to children or others, that's a spendthrift or protective trust, protection of capital for later generations, divorcing management from enjoyment, so that assets may be professionally or expertly handled for the greater benefit of family members, preventing family members from attack by creditors, maintaining flexibility over devolution, so that after one beneficiary died, moves on to the next one and then to the next, tax efficient estate planning, and providing security for disabled or naive beneficiaries. Because you could set up a trust and you could put provision in for accumulation and for maintenance of dependents. The most common differentiation of trust is by reference to the nature of the interest enjoyed by the beneficiaries. So you have different types of beneficiaries. You have vested beneficiaries who are paid outright, and then you have contingent beneficiaries. So which means that they do not get any income or capital until something occurs. The final classification of trust is the nature of the powers that are vested in the trustees, and the trusts themselves will be further differentiated by the powers of advancement or appointment or by the nature of the control. So sometimes the trust itself can have in the deed, can say there is an advancement of capital. Because you know, most beneficiaries are paid income. And capital is left for the remainder man at the end.
Yeah.
But the trustee can have a provision where he can get an advance on capital. And normally that's for an actual purpose. And remember, in the Bahamas and other offshore centers, they have protectors. So the protector is to give advice as to whether or not the purchase is prudent. So choosing a form of trust, the question of tax on creation or during the trust period will often be a major factor. How you're going to be taxed. And that's why the structure is so important. So when you did the classes with Mr. Pinder, he went over structuring. Okay. So it's hard to generalize on tax treatment as well, as all will depend on the domicile and the residence of the settlor and also of the beneficiaries. And then you can look at the residence. So bare trust and nominee trust, everybody know what a bare trust is? Bare trust is when you just hold the assets, that's it. You're not using any discretionary powers, you're just holding it. And what's a nominee trust?
Just holding shares.
Just holding shares. And then of course, sometimes you could have a constructive trust. How constructive trust arises? See that one you don't know?
What the bear trust was holding?
You just hold the assets, you don't make any decisions. There's no discretion in that. Constructive trust normally arises, like they say, operation of law. So, let's say if a trustee doesn't act, the beneficiary sue for breach of trust. But in that act, let's say he sold a piece of property and he sold it to you. And you knew that that was trust property. You become a constructive trustee. You don't own it.
You don't own it?
You don't own it. Now,
You were privy.
you knew. Now, if you didn't know, had no way of knowing,
Right.
and that property was valued $10, and you paid $10 for it, then in law they say that you're a bona fide purchaser for value without notice, and you own it.
Okay.
Interesting.
Yes. Notice is very important. Once you have notice, then you become liable. Then a resulting trust, this is when you set up a trust and it fails. So it goes back to the person who established it. So income arising from the trust property or gains realized in the name of the trustee would usually be taxed as though received by the beneficial owner. So what I did next was I went through another type of trust. They're called precatory trusts. These are words used such as wish, hope, or request, and is normally found in wills. So you can write a will, and within the will you can create a trust. Just by saying the words. I wish to establish a trust for my children in the amount of so and for whatever purpose. Then you can have a secret trust. This arises where there's a will, or you can do it while you're living. It gives no indication that the recipient is to hold the property received on trust. So what you do is you go to someone and you say, I am going to leave you $100,000 to take care of XYZ or whatever it is. So on the will you will see that person's name, but that is not the beneficiary of the funds. That person then goes and do, what you're supposed to do. And the same thing with a half secret trust. Will be effective when the communication to the trustee is made as long as it's during the lifetime of the donor. So again, it's the same thing. The name is not on the trust, but you communicate it to the person, this is what you want them to do. So y'all all women, so y'all don't like the house secret trust, the men love it. We talked about the fixed interest trust already, the protective trust, discretionary trust, and that's where the trustee has all of the powers. And whenever you have a discretionary trust, beneficiaries cannot see the deliberations. They can see the accounts, but they cannot see the minutes. This is not their concern. We spoke about charitable trusts. Whenever you talk about a charitable trust, in order for a trust to be charitable, it has to fall under what they call the 4 heads of charity. So that has to be for poverty, or for religious studies. Yeah, and the religious studies have to be really religious studies, not a cult. Okay? To be for education and for any other purpose that's beneficial to the community. And the wording of that beneficial to the community means it cannot be racial. You cannot say, I am leaving this for all of the little pink children in Nassau. You see what I mean?
Okay.
Because it becomes discriminatory. It has to be all of the children, or all the children in a particular area, not by color or race.
Okay.
Alright?
Okay.
So on acceptance of a trust, a trustee must confirm its appointment, ascertain what the properties are, ensure that the trust property is vested in the joint name of the trustees, then ensure that any trust property is outstanding that he presses for payment or transfer, and if a new trustee, investigate any suspicious circumstances to make sure there is no breach of trust. And when we do succession planning, you will see a personal representative have a similar duty when you become an executive or an administrator. You have the ball has the same duty to carry out. You have a duty to act unanimously, a duty to give account and give information, a duty to invest, a duty not to profit from the trust, a duty to distribute, power of sale, power to insure, power to compound liabilities and settle claims, power of maintenance, power of advancement, and power to appoint agents. Because the trustees cannot do all themselves. And so the law allows them to delegate and to employ agents with the condition that they do their due diligence. Because if you hire an agent who is not fit and proper, one, who doesn't have the requisite skills, you'll be sued for breach of trust. Because what happened is, the trust is gonna lose money. The most important thing a trustee does is his power of investment. Because that's the purpose of giving you the money, is to invest it in order to pay income and capital. And if you can't do that, you're going to be sued. So it may not be the settlor and his children now. It could be the great-grandchildren who sue you. They look at what was initially put there, how much was spent when they get the financials, and they look at the market conditions and they say, guess what? At this time we should have had $10 million, not 1.5 million. What happened? Who made a wrong decision? What did they invest in that they should not have invested in? Who gave them advice? Did they listen to it? Did they go outside? And then they will sue you. So breach of trust, this is committed by a trustee who fails to carry his duties in relation to the trust, or if he exceeds his power. And breaches can be of various ranges. It could be a misconduct, which is a misappropriation. You won't be hired anymore. Innocent breaches, failing to follow directions in the trust instrument. And then there are others, investing trust funds in unauthorized investments, paying trust money to the wrong person, making an unauthorized profit, carelessly allowing trust money to remain in the hands of one trustee only, or failing to exercise their discretion in relation to trust matters. So it is an onerous task.
I heard of an attorney who actually, they had the power to sign
as an underlying entity for a trust,
Mhm.
held the assets, and they sent, I think it was like over $1 million, thinking it was an email, it looked like the exact email from, one of the beneficiaries.
Mhm.
But the account, of course, was different, and they sent out the funds thinking they were taking instructions from the beneficiary without doing the formal callback, verification, all that, and it's like over $1 million.
Mhm.
Yeah.
And then you have
Yes.
sometimes trustees take the monies themselves. Mhm. So one of the key things a trustee has to do is whenever he makes a decision, he cannot think, let's say if he's looking at that Coke soda over there and he say, Coke tastes good, a lot of people buy Coke, it's moving up, I think we should buy Coke. Invest in drinks or whatever it is.
Right.
He has to look at what is his investment strategy? What was his objective? And he has to be mindful. Whenever he makes a decision, it must be what's in the best interest of the trust and what's in the best interest of the beneficiaries as a whole. He has to balance that. The same way when he distributes income and capital, he has to balance it. He cannot favor one over the next one. Otherwise, he'll be sued. All right?
Okay.
So that's trust. Tell you all I can get you there.
You ain't riding on the horse, okay.
I can make sure you get there. Okay. So, there's been a lot of hype, a lot of talk in the papers today, in the papers yesterday, last month, the month before. Everything is about offshore jurisdiction. And the Bahamas is one of them. So we just looked at one of the products that we offer, which is a trust. Now, an offshore jurisdiction doesn't have a definition. People come up with different words, means it's just not on the mainland. But when you look at it, the Bahamas is not on the mainland, it is an island. And all of these islands, whether it's in the Caribbean, it's in the Far East, they're all called offshore. Because historically, from World War I, World War II, those persons decided to move their monies from the continent and put them on these little islands for protection. Good evening. So the IMF defines offshore as a country or jurisdiction that provides financial services to non-residents on a scale that is incommensurate with the size and the financing of its domestic economy. That don't sound familiar to you? Isn't that what the OECD is now saying? So you had it on one side in 2000 with money laundering. Then you come now to 2018 and it's on taxation. So think about what I just said. It all started from World War I, World War II. Monies move to Switzerland, England, and then they move offshore, Jersey, Guernsey, then they went to all these little islands. So first it was money laundering, and now it's what? Bring your money back home so we can tax you. So you can help us maintain our country. So what they are looking at now is that these offshore jurisdictions have a lot of assets under management, but isn't commensurate with their size. We're 21/7. One of the guys said, I think it was 2 years ago, it was 21/7. The amount of people on that island, if you divide that by how many of my experts, how can they manage it? He said he said it doesn't add up. What are they doing with all of this money? It's not possible. So they say the offshore jurisdiction usually have low rates of personal and corporate taxation or do not impose any direct taxes. So this is another reason why they're all on the offshore banks. Because they're saying first, the amount of assets under administration is not commensurate with the amount of skilled workforce. Secondly, you're not taxing them. They're not paying taxes where they live. They're not paying taxes where their money is housed. So who's getting the money? So it is applied where financial transactions are carried out from a jurisdiction removed from where the client has initiated the transaction, where the client doesn't live or reside. So this is an issue they're having. You live in A, your companies are in B, you house your money in M, L, and P. So who exactly are you paying? And when it comes to these little jurisdiction, like they said was this week, or was it Friday, they're selling residence now. So that means you're not only not paying corporate tax, you're not paying succession tax, you're not even paying living tax. You're paying no tax. So this is an issue that they're having worldwide. So offshore centers, traditionally, they had them in they had them in 4 centers, really. They have in Europe, Liechtenstein, Malta, Madeira, and Isle of Man. Then they had the Atlantic and the Caribbean. They had Anguilla, Bahamas, Barbados, Belize, Cayman, and Panama. And then you had the Cook Islands, Mauritius, Singapore, and Vanuatu. Luxembourg and Hong Kong are considered onshore, but they're the largest users of non-residents. So you can take the same thing with the United States. Delaware is onshore, but is offshore. Then they went to Puerto Rico, and they took Puerto Rico and they gave Puerto Rico a product that they can use as an offshore product on an onshore island, a territory of the United States. You're studying taxation, so you gotta keep up with them. So the IMF said in 2000, this was their group of offshore jurisdictions. Guernsey, Hong Kong, Ireland, Isle of Man, Jersey, Luxembourg, Singapore, Switzerland, Andorra, Bahrain, Barbados, Bermuda, Gibraltar, Macau, Malaysia, Malta, Monaco. They're going on. Vanuatu, Turks and Caicos. You see how long this is in 2000? 2007, what do you see? You see that? Bahamas, Bahrain, Barbados, Bermuda, Cayman, Cyprus, Guernsey, Hong Kong, Singapore, Ireland, Isle of Man, Jersey, Latvia, Luxembourg, Malta, Mauritius, Netherlands, Switzerland, UK, Panama, Uruguay, and Vanuatu. You said they cut it down? And 2018, what do you see? They cut it down more, and they have actually cut these down based upon assets under administration. That's how many has left us and gone other places.
Where's the Bahamas on?
We're not in this grouping in terms of size. We're not here in terms of size. We're not here. So, with the international changes in 2000 by the OECD, the IMF, and the FATF, offshore centers are now less attractive to the initiatives on common standards, regulatory compliance, and banking transparency. So it's not just the CRS. We all panic for CRS. More than 30-35% of our clients left for CRS. So they finished with CRS now. The ending of CRS will come in another 2 years when they start asking questions and more information. So they finished with CRS in July, August. Now they're coming with BEPS. BEPS will attack all of our IBC, all of our foundations. And the pressure this week is they want that beneficial ownership registry. They want it open so they can tax all the people who are left here, which is scary. Because they put us on a list with 5 other countries that we don't even know. Botswana. That's where we are. We're at the bottom of the list. Nobody wants to do business with us as a country. They say we are high risk. Money launderers, tax evaders, terrorists, proliferation of weapons of mass destruction, bribery, corruption. That's where we are. Why you look like that? It's true. It's in the paper. It's not good. Yeah. It's not good. So it's not just a tax haven now. We're not considered not just a tax haven. We are now considered as an improving country at the bottom of the list at the FATF.
As much as we've done.
And as much as we have done. But you see, I guess when we went in, we said we are not having an open registry. Okay. this is what we're gonna give you. We said we'll look at BEPS, we said we'll figure out how we can structure corporate taxation to show there's some meaningful presence of them being here, having so many IBCs. The question was, how does it benefit you? So they're saying is, if you have someone here, it must be meaningful, which means that the IBCs now have to establish a physical presence. The whole attractiveness of the whole product was flexibility. You take your company in your pocket with your seal. Now you can't do that anymore because they want you to have an actual office with staff. Whether that's 1 or 2 persons, and that's rent. That's more expense. So that's another thing they have to look at. But to top all that off, if you move out the IBCs, the persons with individual accounts who hadn't paid their taxes, who didn't do voluntary disclosure, all decided to run and go back and pay it. So the money that they had saved, they had to pay their taxes with it, so there was no need to keep an account here. They now said, okay, you went to the OECD and did a Model 1A where you carve out your little specific for all your little products. All right, open the registry. Open the registry. And we still, even though Bahamians look at it from the opposite side and look at it internally, we're still screaming about 2% NHI. As far as these people are concerned, there are no taxes here. We don't pay taxes like a normal country pays taxes. And so you're still going to be considered as a tax haven. Because think about it. If I'm over there and I pay 45% and I come here and I pay what? 2%. And VAT is on yeah, it's nothing. And there's no income tax. There's no road tax. You're not paying no tolls for nothing. What is it? So it's both ways. So use of offshore trusts. When a settler has decided to establish a trust, he or she will consider where the trust is to be based. And there are several things. What's the governing law? Where are the assets? What's the residence of the trustees? Because normally you like to have the trustees either close to the beneficiaries or in the same jurisdiction, because then you have taxation issues. Because whenever you pay them, you have to wonder, should I pay them now or should I pay them later? Because they may have different tax periods. Then the manner in which the trust assets are administered may be subject to the jurisdiction of the courts of a different country. So all of that has to be considered. And now you have to think about all these beneficiaries all around the world now who have to pay taxes. And who haven't declared taxes. That's another issue we have. So Sandler's reason for creating the trust and what he seeks to gain long term is the starting point for determining where a trust should be resident for tax purposes and what the governing law should be. A trust offers a number of significant advantages over retention of assets in one's own name, because you could use it for tax and estate planning, retaining control of the assets, like you say, a settler-directed trust, maintaining flexibility in giving gifts, securing freedom and respect of testamentary disposition, because you leave a will, then of course you have to wait until the probate and all of that, but if you put it in trust, it's just immediate. Providing a possible safeguard of assets from attached either by creditors or in matrimonial proceedings. And that one is get kind of tricky too, because you can put the assets within a trust to avoid giving your spouse a part of it, but if the spouse can still go to court and prove that the assets within the trust you sought to defraud because you knew these assets and they were made together, they can challenge the trust. Preserving flexibility in the framework of commercial transactions. So some people, they establish a trust and then they put operating companies underneath it, and then the profit from the trust moves back, from the companies move back up into the trust. So the financial services offered by offshore centers are banking, trustee services, and you know banking now is shrinking, not just in terms of offshore banking, but also in retail banking. So retail banking is shrinking in terms of computerization, and offshore banking will now shrink after all of this taxation by computerization. You have trustee services, you have company and corporation and company management, that also will shrink. You have investment management, and investment management is the United States and the EU just brought out new rules with investments and taxation. you have custody of investment, you have captive insurance, you have pension funds, ship registration, and ship management. And there are a lot of reasons to go offshore. The main one is client confidentiality. But client confidentiality, again, has gone out the window. Because you can't hide anything. So when you report, and you report the controlling person, the only saving grace you have is if that controlling person is in a non-reportable jurisdiction in their own country. Because if they are reportable, then when it gets to them, then they have to report. Who's the PO? Yeah. You look for local expertise. Well, we have that. I don't know for how long. We're dying quickly. Communication, geographic distance, because we always pride ourselves that we're so close to the United States and to Latin America. Legal system, which is our common law system. And then exchange control, there's no exchange control. And then taxation, reduce the possible potential tax liabilities. Attitude of local government, as you can see, the government now is fighting as hard as they can. I mean, I don't know what would have happened if they didn't physically go there. If they didn't physically go, I guess we would have been closed. They're arguing as much as they can, but without a presence there, I guess we would have been closed. Yeah. Political and economic stability, the language, costs, reputation of the center, same time zone and climate. That language is another issue, because we got rid of the Americans. But then there are other people who are unbanked, but they don't speak English. Because these are the people that the United States will not do business with. So we're in a dilemma. Yeah. We everybody learned French and Spanish and English and Italian, and there are other languages. So that's something that's for the young people. Yeah, because the up and coming millionaires are the Chinese, the Chinese, you have the Chinese, you have the Iranians, you have the young Russians, you have the people from Ukraine and Latvia, and those are very rich. So those are some languages you have to learn. Yeah. A bank may decide to provide banking services from an offshore financial center because it's likely to be a lower rate of taxation. I put this piece in here because this is important to understand why the people from the north came down to the Caribbean. And it was for tax advantages. Yes. And then as the expertise in these islands built up, the cost got to be too much. And so they moved to the other island where they are now, where the cost is less. Yeah. Okay? So that's how you reduce it. Reduce the cost by moving to a cheaper jurisdiction. But think about it, when they first came, they're sending my profits each year, $5, $10, $20 million. Money was booming. And at the same time, we developed the skills. But what we didn't do is open our own banks. You just took the money and increased the lifestyle, and then used the money in order to build the economy. That's food for thought. Choosing between an offshore branch and an offshore subsidiary. With a subsidiary, the bank has to invest capital. With a branch, it doesn't have to. So you would see before 2000, there were a lot of branches here. And then because of the 2000 change in legislation, they had to become subsidiaries. So there's more mind and management here rather than mind and management in the home jurisdiction. Confidentiality is one of the features of an offshore financial center. There have written many books about confidentiality in offshore centers. Now that's the crux of what an offshore center sells. Remember I said going back to World War I, World War II? When those people would have put their monies offshore, they didn't want nobody to know where it was.
Right.
Some died and left it. So nowadays, there is no such thing as confidentiality. I mean, we know that by law, information from a client can only be disclosed under 4 conditions. By law,
Right.
bank's interest, in the public interest, or express or implied consent. But when you take that and wrap that around all of the other agreements that we have done, automatic exchange of information, the agreement with the United States, even though they say it has to come by law, which means by a court, the point is that it can still be disclosed. You can't just walk up and say, can I have the information?
No.
But you can get
You
it.
can still-
Yeah.
yeah, still can get it. Subpoena.
Yeah, just get a subpoena and get it. So in common law, I have how it arises. A confidentiality is either an express contract, or it could be a relationship with your attorney, or under the law of tort, information with commercial value can, under certain circumstances, be protected. So when the government had all those heads of agreement, and you hear the opposition and all the people on the talk show saying, we want to know what the information is, tell us what the information is, don't, no. No. It doesn't happen, nowhere. So I don't know why they keep asking. So, so the next thing I've given you is the common law case of confidentiality. And everybody who has done banking law and work in a bank know what that case is, which established that every banker has a duty of confidentiality by law. And there's a penalty if you breach that confidentiality. So, when you talk about being in an offshore jurisdiction, some of the key things is should they have a settler control. Mainland doesn't like trusts that have settler control. They don't like that. That means that the settler is directing everything. They do not like that. Then you have forced heirship. They don't like when persons come from a civil jurisdiction and establish a trust in a common law jurisdiction. Again, that circumvents their succession because they have forced heirship. They don't like that. And of course, asset protection. And that's one of the main things we offer around here, not just estate planning, but asset protection. And that's why they're after the registry. They want to see who owns these assets. So offshore captive insurance, limited partnership, and ship registration. Now, our captive insurance, you can read it, is a very small business in the Bahamas. When it left here, it never came back. They tried to revive it again recently. It still isn't as strong as it was. Those who moved to Bermuda stayed to Bermuda. So we really just have the domestic insurance and then the external insurance. But we don't have captive insurance here. So you can read that. Then-
Can you give an example of a captive insurance? A company, captive insurance?
We usually have a couple of years. Yeah, they reinsure. us.
Reinsurance?
They
Okay.
reinsure us. We don't have much.
Thank you.
But apparently we had a big one, a big market here, before 2000, and they left. Partnership, there are two kinds, general and limited partnership. I don't think we have much of these here in the Bahamas in terms of an offshore, from an offshore perspective, but I just put it there in case you wanted to read something interesting. Huh?
From UK and England.
Yeah, but it's not much. No, people don't come here to
No,
establish partnerships,
yeah,
no.
UK.
No. So in the US, they use it as an asset protection vehicle in the US. And then we have ship registration. Did they say we carry, we have a lot of ships? I don't know how you rank, number 3 or 2? 2 or 3? 2 or 3? 2 or 3. So ship owners have the option to choose the laws and regulation of another marine administration rather than be governed by their home country. So they normally would carry the flag of the Bahamas on their ship. But it means that they're governed by the laws of the Bahamas. So the benefit of offshore ship registry, when did they come for this? Yeah. Confidentiality. Confidentiality. To avoid political problems in the home country, to circumvent local legal issues, taxation, because there'll be low tax or no tax, yeah, you coming for them next. And then lower cost, cheaper to register and to manage. Yeah, pray not. Y'all have to learn how to pick peas. Mhm. And then,
You gotta do it first.
yeah, yeah, good, yeah, learn how to grow it. Then the next one I put is an offshore, is a company. So you know here in the Bahamas, we have a company that can be incorporated under the Companies Act or a company under the IBC Act. So everybody knows a company is a separate legal entity. Once you put your assets into a company, it's separate. Yeah. And there's unlimited liability, and the company can be incorporated with shares or by guarantee or hybrid, shares and guarantee. Management and control, the company is an artificial person and cannot manage itself, and that's why you have the shareholders and then you have the board of directors who manage the day-to-day management of the company. Then you have the governing documents, which is the articles of association and the memorandum of association. And in most companies, the purpose of it says to do everything that is in compliance with the law. So it leaves it general. Your business license may describe what it is you're going to do, but your memo and arts is left open. And so the board has to follow what's in the memo and articles of association in terms of the day-to-day operation of the company. So you can use the company for tax planning, succession planning, to avoid probate problems, asset holding, trading activities, confidentiality. And you know, we just did our new law after Bahama on liquidation. So you can terminate a company by voluntary liquidation, dissolution, or you could strike it off. So once you become a director of a company, you have a fiduciary duty. Remember that fiduciary came out when we talk about trust. So whenever we say whenever someone becomes a trustee, or a personal representative, or they are a director, you will never see it in writing. Just by those names, by common law. You know what I mean when I say common law? What do I mean when I say common law? What do I mean by common law? Hmm? No, not by statute.
No, that's what I mean.
When we say we are a common law jurisdiction, it means that our laws came from the motherland, from England. So when we say by common law, it arises just by law in being a Commonwealth jurisdiction. So whether you're a trustee, personal representative, or a director, a fiduciary duty arises. It's not written, so you must know what it means. So if you become a director, you have a responsibility. It's not going to set it in the contract. All the contract is going to tell you when you need to come to attend, how much you're going to be paid, and where you should be. But with that job comes a responsibility. One, you have to avoid conflict of interest. Something that behemoths still don't understand what that means. They have a duty not to make a personal profit. They don't understand what that means. Because again, I'm telling you, because when you become a director, it is not written. And so no, it's not assumed, it's inherent in that position. It is inherent. So if no one never said to you, or you're not a lawyer, and you never did a class in company law, you would never know that when you become a director, these are your duties. Because it's not written anywhere. It's inherent in that position by law. No conflict of interest, none whatsoever. You don't sell things to yourself, your family, your friends, your lovers, and whoever else. None of that. Okay? You can't make a personal profit. Cannot do that. Because you're acting as fiduciary duty. You have a general duty of care. So you have a certain standard to do things at. And everything is always what a prudent, reasonable man would do. Not what you feel like doing. Right? Then you have statutory duties. So it depends on the Companies Act itself or the IBC Act has certain statutory duties listed in the Act, different from these fiduciary duty that arises just by common law. And then if your company is licensed or registered by a regulator, you have another set of duties to do. And you have to be aware of all of those. So, and any other additional duties that is imposed by your articles of association. So when you become a director, you have all of those duties. And that's why they keep getting into trouble. Because they take on these directorship positions and they don't know what it entails. They don't understand. So a director also has powers. And some of these powers are actually in the memo and arts. And when they're not in the memo and arts and they're silent, then you go to the Companies Act or the IBC Act. Okay? So they have the power to borrow or to charge assets of the company. They can open bank accounts or execute documentation. They can allot shares, remove a director. They can bind the company. They can appoint agents. They can declare dividends. They can call meetings. They can employ agents. These are just some of the general things, the powers that they have. But the memo and arts will actually stipulate what they can and cannot do, and how much voting power they need to do certain things, in which they have to follow. So there are different types of directors. You have an associate director, a non-executive director, a shadow director, an alternate director, a nominee director. It doesn't matter what word you put before it, a director is a director. That duty arises no matter which one you will call yourself. So you could be appointed as a director. She could be my alternate, which means that when I cannot attend, she attends. A non-executive director is a director who is not a part of the company. You bring him in for a certain skill. So whenever you make up a board, the composition of a board is based on skill sets. So if you are selling toys, who should be your director? Who should be on your board as a director if you're selling toys?
Expertise.
In toys. What else? Someone who knows marketing. What else? Financials. You need a lawyer. What else you want? Someone who knows. What else? Accountant. Well, it's a financial person, accountant. Yeah. What else you want? You need one more person. And we're all in this room. You need a woman. Parent. Yes. A mother. Yes. That's how you make up a board. Because you could be buying whatever, designing whatever it is, or selling whatever it is, but if you're not capturing the market, because a marketing person is only going to tell you how to sell it. You got to know who's going to buy it. And exactly. Okay? Then you have a shadow director. This is someone who the board knows and who has too much to say. And then when he goes to meetings, the other directors who don't put on their thinking caps decide to follow what they say. And a shadow director, be very careful, because they can be sued as a director because you have too much power. Okay, and then of course we know who a nominee director is. Okay, so taxation of companies and offshore centers. A company would usually be considered to be resident for tax purposes, either where it is managed and controlled or where it is incorporated. So normally for companies you would say it's incorporated in the Bahamas, but if all the instructions are coming from England, then it's taxed from there. Offshore centers are generally low tax centers and provide tax planning opportunities. Generally, a company's place of residence would be country where it was incorporated, and some offshore centers impose a system of corporation tax. Others do not impose corporation tax. So that's what they want us to do now. We say we have business license fees. They say no, they want a corporation tax. So when we start taxing these IBCs, then this is going to be another issue. But the thing is, if the pressure on us, the question is, do they have the same pressure on St. Kitts and Nevis? Do they have it on St. Vincent and the Grenadines? Do they have it on Seychelles? Because they all offer the same thing. And if we're the first to be out the gate and doing this, then that's it.
That's right.
Because you don't know what powers behind those other countries and how they can bargain to keep what they have. Yeah. So non-resident companies, a company which applies for non-resident status based in a low tax center would be assessed to tax locally only on his income and gains from local activities of which there will usually be none. So you see, this is why they're having an issue. You have a company that's incorporated in the Bahamas, but they're not really taxed on their income. And that's what the OECD is having an issue with. What are they giving back to your country? You're not taxing them. Any income or gains made or received from its overseas activities will not suffer any local taxation because we don't tax them on anything that they make. Traditional purpose of non-resident companies was to provide clients with the opportunity of owning a company which could take advantage of favorable offshore tax rates and which they could control and operate. But of course, there really is no taxes. Tax exempt companies in some offshore centers, a company can relinquish its resident status in return for tax exempt status. So some of the offshore centers have a category called tax exempt status. And they don't have to pay any taxes, but they call it tax exempt. They're waiting now to see when they're gonna attack those ones with all these tax exempt. Because everything pressures on us with the IBCs and say we don't have the right corporate structure. But they have other jurisdictions that have carved out what they call tax exempt status. Similar to an IBC, but they call it tax exempt status. And Puerto Rico has that. And Cayman has one too, yeah. A lot of them have this little small thing called a tax exempt. So if a company is granted tax exempt status, it will be assessed to local tax only on a similar basis to that applied to non-resident companies. So it's roughly the same thing. It's the same thing. Nominal fee, duty paid to the local tax department. This is what we do too, right? They are usually permitted to create or perform business activities in the offshore center. Same thing. Must not be beneficially owned by a local resident or local trust. Same thing. But they call it tax exempt. Maybe we should change the name.
Yeah.
So the European equivalent of IBCs, they call them international companies. We call them international business companies. They call them international companies. Similar in nature to a tax exempt companies, but can elect to pay locally at a rate specified instead of a nominal fee. Not widely used by individuals, but can provide tax planning opportunities for parent company who may wish to reduce the effects of controlled foreign company legislation. So I have here IBCs, they're offered in the Caribbean, and there's a nominal filing fee and it's easy to incorporate. So that's what the BEPS is about. Base erosion profit sharing. And of course, I have the regulation of offshore companies. They have local record keeping and reporting requirements. Must have a registered office, a registered agent, company registers. But you know, if they get away with what they want and they must be physically present, that means the FCSPs are going to lose business. And that's a little niche market that we carved out in 2000 following after Cayman doors to provide that service to those clients. Company registers, annual returns, financial statements, declaration of beneficial ownership, and then of course the register of shareholders, directors, and officers.
Do you ever get access to any of these committees? Was that?
No idea.
Minds on these committees. I see innovative minds on these committees. This is our industry.
All right.
Like it's complex.
You happy?
Yeah.
Okay.
Wow.
Maybe I'll go.
Yes, you can still.
Right?